Hi everyone. Good morning or good afternoon. Actually, it's 12:01. Welcome to today's webinar, and thank you again for joining us on a weekly basis. I do appreciate everyone's attendance or everyone who is viewing this afterwards as well. So today's webinar is an interesting topic, but it is also something that we've already discussed, but we'll discuss it a little bit more in detail. It is about partnerships and co-ventures. So, welcome to today's session. We're exploring different structures, what they are, when to use them, and how to protect your interests. Whether you're a business owner or consultant or a legal professional, understanding these models will help you make smarter decisions and reduce your risks. So, a little bit about me. I am a experienced, knowledgeable legal professional. However, my experiences come from a well-rounded background. I have not only been a lawyer, I have also been in the court services for over 8 years. I've also worked with various individuals like justices, lawyers, legal staff, court admin, and the public as well. And I've learned a lot of different techniques and knowledge and legal foundations. So my experiences is quite broad and different. And if you ever need to ask any questions regarding specific areas, you should always email me, which will allow me to respond quicker and faster than phone calls. And sometimes it may require further in-depth meetings. So remember that I might ask you to book a meeting with me in order to speak to it further, because I can't give legal advice on matters that are pertaining to specific areas when I don't have enough information. Okay, so let's go into our today's topic. Why partnership structures matter. Your business structure isn't just a formality. It defines how much you're personally exposed. So how you're taxed and who makes the decisions. It's crucial to align your structure with your business goals and risk profile. These are important because you will incur legal liability, you will incur taxation issues, you'll incur like ownership and decision making concerns, flexibility and exit options, regulatory compliance. These are all things that you can encounter during the process of having a partnership and any kind of structure that is similar to a partnership, even co-ventures. So let's talk about what co-ventures are. Co-ventures are not partnerships. These are joint business arrangements, and they are for specific projects, specific goals, or even sometimes a property that's shared together, but yet they don't have a partnership, because co-ventures have a different feature from a partnership, whereas a partnership has specific requirements, including contractual obligations and regulatory requirements. Co-ventures do not have these regulatory requirements. They don't fall under the Partnership Act, or any other, even Limited Liability Partnerships Act. So remember that you must actually make sure to consult with a lawyer if you think you might have accidentally gotten into a partnership agreement without knowing it yourself. This is important because you could end up in court dealing with these kind of issues and figuring out whether you need to decide whether this is a court venture or a partnership. And we want to make sure that you can decipher these differences. Whereas if you do it on your own, you might have a very difficult position where you might be liable for someone else's decision making when you don't know if you've actually created a partnership without realizing it. So let's talk about some features of co-ventures. These are temporary and focused in specific areas. Like they can be property related, they can be a business related, but not a real actual business. You're considering yourself a sole proprietor and you have a taxi company that you rent, you purchase the vehicle, you have your own insurance, you work with an individual who shares in that insurance and the business, but they are not actually partners because they have a time allotted relationship. It's like a shared venture, but without actually being a partner because you only take the income based on how much hours you work with the taxi company, that specific vehicle. Okay, so even in the property, you share the property. You have a property where you own it with somebody else, but you rent it out, and then you each share that rental income equally. That is like a co-venture, but make sure that you're not committing to it in a long-term perspective with, creating further aspects of it as a partnership. So these are things that you need to really look at carefully. And if you have a bit of confusion or you're not sure, a contract would actually prevent specific partnership agreements from forming. So these are things that you need to consider because remember, co-ventures are not partnerships. They don't share ownership unless otherwise agreed in a contractual basis. So you want to make sure you want to put that in a contract saying, we're sharing this property, we're getting the rental income, but we're not actually a partnership. We're not doing any business in common. We're not doing any partnership that will allow for a profit to grow the company because you're not growing a partnership. You're basically just limiting that one particular venture as this is just one. But you can create a lot of different forms of organizations within a partnership that actually allows for a co-venture, which is a temporary business structure on that temporary purpose. So remember, you have to have contracts. These agreements will allow you to understand the differences and it'll allow you to diverge from actually having legal repercussions. So these are important. These are things to consider when you're dealing with co-venture and as well as when you're dealing with partnership agreements. So pros and cons of co-ventures. Pros, easy to set up, resource and cost sharing are important because co-ventures, you're basically saying we're sharing everything equally and we're putting in the investment specifically this way. It's a 50-50 cost flexible roles, which technically there's not a lot of roles because your venture is specific. It is actually targeted. It is in a very organized fashion. So you're not actually going into several different areas. You're only dealing with that one matter. Cons. Legal ambiguities. So this is where you need to get that contract completed because if you don't, it could be constituted as a partnership in the court's perception, as well as because if you're doing a business in common and it's for the view of profit and it's two or more individuals, it could eventually transfer into a partnership into the perspective of the courts, especially if you are, let's say, you're creating a co-venture and then you decide to have individuals sign agreements on your behalf. This starts developing a partnership role because now you're kind of developing a business and for a view of profit and there's agreements on different levels and you don't want to have those kind of information going out there without, which is creating a lot of ambiguity. But co-ventures do limit liability. There is no liability shielding when it comes to specific business structure, though. So remember, you need those contracts, or you're going to incur further liability if the person is making agreements on your behalf. High dependency on clear contracts. So remember, it's right there for you to view. All right, so what is a general partnership? A general partnership, we've discussed this in several several of our webinars, my webinars. But as you can see, it is a clear definition of two or more individuals, entities operating a business with the intent to earn profit, sharing risk, and control. However, general partnerships can be formed in multiple ways, yet it is always governed by the Partnership Act. And we have to remember to look at those regulatory requirements when we're dealing with the partnership agreements. These general partnerships are formed using these Partnership Act and creating those Partnerships Act into the contracts that you form. Partners have equal rights and responsibilities unless agreed otherwise. So these can be depending on the type of relationship you have. If you decide that you're going to have a general partner, but you're going to have a partner who's going to be the managing partner, and they will make all the management decisions, and the other partners are voting rights. Whether if there's multiple partners, multiple general partners, you want to be able to create that voting rights, and you want to have that managing partner, because you can't have every day-to-day decisions being made by like 10 partners. Let's have everybody get in there and try to figure that out. That's not going to really result in a good business structure. So remember to get these contracts written up, indicating who's going to be voted in. If there's two or more partners, okay, there's two partners, you could have an equal say. But what if it comes to be a point where you have 10, 15 general partners? Now you want to make a structure where you have a managing partner, and you have that managing partner voted in by all the general partners, and that managing partner has the ability to do the day-to-day decisions. Are they going to do an agreement where they create a loan? Are they going to be doing, these are things that, yes, you want to have a general say in the partnership, but at the same time, you don't want to have a lot of conflicts. And this is where, if you have 10 or more people who are general partners, you're going to have a constant conflict, and you want to be able to limit that issues. So this is where we want to create those structures within the contract, saying, okay, who could be voted in as a managing partner? What are their responsibilities and roles? Who else would you want? Like, do you want a financial manager? Do you want a marketing manager? If there's a multiple managers, we have to be able to increase the contract, build another build more within that contract, and build a bylaws so that you can actually get these voting rights, and you can get the specific roles. So remember these concepts. They're important. So, legal characteristics of general partnerships. No separate legal identity from partners. None of these individuals are going to be separate, not like a corporation. It is the individual person who is a part of the general partnership. Unlimited personal liability. So now you're not limited in your, even in your personal debts, including if you have a house, it'll still be within the context of liability. A person can go after your property, personal property, any kind of property that you own. So remember that you're not limited here. Binding authority. One partner can act on behalf of the other partner. This is important because if you do not have the managing partner and you do not have the voting, and you are just two members who are partners or three members who are partners, here you will encounter the issues of where, okay, if I go make an agreement with my friend, let's call him Luke, and Luke and I make an agreement, but I have a partnership with, let's say, Matthew, and Matthew and me didn't discuss this issue before I went and made a partnership with Luke. So now Matthew is still liable for my agreement with Luke, even if he wasn't aware of what agreement I made. So these are things to consider in a partnership. You want to make sure your agreements or your agreements and your bylaws all have important facts in there. Who can make the decision? When can they make the decision? Should they be consulted on these decisions before they are made, especially if there is a liability consequence to the other partner? So you can actually integrate that into the partnership agreement. Okay, if there is an amount of 10,000 and more, I am going to have a loan where it can create a liability on my other partner, and then the amount of the agreement is 10,000 or more, then should my partner be consulted? These are things you can actually incorporate within the contract. So these are important factors to consider. What to use when to use a general partner. Sorry, a general partnership. GPs are ideal for simple, trust based businesses like small consultancies or family run shops. But as a scale, or let's say the business becomes riskier, the structure needs to be upgraded. As I indicated, the business structure, you need to really trust your partner. I have a trusted partner in my best friend, who is my my dog, and I can say to him, "Can you do this?" and he will do it. But let's just say you had a partnership agreement with a person you don't know, and he's not a member of your family. Let's say I have a partner who's my husband, who I actually do a partnership with. Now we have a trusted relationship and we can make decisions together. But when it comes to external factors, you have no idea. So make sure you're actually looking at these factors and these risks before you create the business structure. We want to always be able to be ready for any liabilities and legal consequences so that we're not incurring hundreds of thousands of legal costs at the end of the day. Civil litigation is not cheap. It's not it can go for many years, and you don't want to risk those issues. So remember to consider speaking to a lawyer, or at least making sure you write down all the risks that you're taking and determine if you're weighing the pros and cons before you proceed. So risks of general partnerships, as we indicated, you have a common risk including joint and severe liability. So severe liability. Um, Conflicts due to unclear agreements, difficulty securing financing, challenges with partner exists or dissolutions. So remember, when you're doing that, creating liabilities, especially when you're taking loans and stuff, you're actually incorporating it within the partnership. This means that in the long term, both partnerships or any partners who are involved will be liable and at risk, as well as the challenges of exit. Like a partner wants to leave, they can't just leave. You have to make sure that all the liabilities are covered. And if they do leave, you might be able to sue them for that loss, any liability that costs that occurs because of them leaving. If their reputation is their leaving is causing the reputation of the firm to deteriorate, this is something to consider, right? And if they were a guarantor, they're even if they leave, that doesn't mean the guarantee is going to disappear. It's still existing there. So you need to make sure all of these factors are considered when you're actually dealing with it, especially if you're the one who's trying to say, "Oh, I'm no longer interested in this partnership." How are you going to take into account the liabilities, the loans, the guarantees that you've made, and including any losses? If you leave the partnership, are you going to be able to get the funds back for the shares that you've input into the partnership? So consider these factors. So this is a limited liability partnership as well. Like usually general partners will have mostly only general partnerships, but you can incorporate the general partners with a limited liability partnership in that they they only provide an investment and they don't have any input into the business. Where if you're trying to avoid any risks and losses in your personal like perspective, that when you sign up for a partnership, you don't want to risk any further than about $20,000, and you want to only invest that $20,000, and that gives you any kind of income or any kind of return at the long run. Those are aspects that you should consider when you're dealing with limited partnerships, sorry, not limited liability, limited partnerships itself. Limited partnerships are only in conjunction with general partnerships. You can't have limited partnerships by themselves, because if you only have limited partnerships by themselves, who's going to be the one who's taking the liability? In the end, someone has to expect to be taking the liability. So only you have to have at least one general partner, and all the rest of them can be limited partners, but you can't have all limited partners, because at least one partner will have to be making the decisions, will have to be running the day-to-day operations, will at least have to be able to conduct their business on a regular basis. Whereas limited partners have no opportunity to make decisions, have no opportunity to even have an input. Well, a limited input, but it's very, very like it's to the point where it won't affect the business's structure or investments or long-term goals, in that they're assisting. Let's say I'm working as a receptionist and I'm putting in a limited partnerships, or I'm working as a clerk or someone who's assisting the business, but I am not involved in making any management decisions. So think about these concepts when you're actually getting into a limited partnership or a general partnership. What kind of investment and what kind of liabilities are you actually looking to gain? What is a limited liability partnership? We've discussed this before, and this is usually something that is particular to professionals, mostly lawyers or accountants, but there are other limited liability partnerships that are architecture firms or specific organizations that have professional bodies that regulate them. These are management control for partners and limited personal liability for other partners' actions, common in professional services, as indicated earlier. Key features of LLPs. Each partner is protected from liability from another's misconduct. And this means that if I have liability insurance. And if I created a partnership with another lawyer or another, well, most likely I can't do a partnership with other individuals like accountants, but I could do it with other lawyers. So if I wanted to create a limited liability partnership with another lawyer, I would have my own liabilities. That means any issues or any errors or any omissions that I have, or any mistakes that I make within that limited liability for the purpose of my clients, or in particular any kind of dealings with my clients, would be my liability. My insurance would have to deal with that, whereas my partners would not be dealing with that issue. Must be registered under provincial LLP statutes. So yes, this is a requirement. It's under the legislative requirement, as well as within the context of the fact that you are registering under the regulatory body as well. Still allows pass-through taxation. So yes, these are usually the individuals would be filing their own taxes, or if the limited liability partnerships, as previously indicated, let's say I form a corporation, I could actually create a limited liability partnership with another lawyer if my corporation is forming that partnership in a limited liability capacity, because it's a my organization is a legal organization. So this is a bit more complicated structures, which we will speak about later on. But just a little bit of a tidbit there for you. Requires annual reporting and governance compliance. So this is required for most regulatory body, like most regulated professions. So in that concept, we all have to deal with those. And we have our regulatory bodies that we have to actually file compliance requirements with, as well as the ministry, which business registry, which we would have to file our regulatory requirements, so that in case of taxing or any other requirements, we're dealing with those matters. Okay. Our next. So, when to use an LLP? Well, this is important because it's only required by the professions. So, people in the medical practice, people in law, accounting, consulting firms, architecture, specifically regulated professions would be using these kind of firms. And it would assist because each of those practices requires a regulatory body that is already dealing with these professions, and that's why it'll assist them in preparing for any kind of further um, like liabilities. This actually limits their liability to the individual person instead of the whole firm. If one person makes a mistake, they are not all liable for that individual's mistake. And it actually gives more success to those firms because the the businesses will become better structured, and they would also allow those individuals to be more successful without having to worry about someone else's liability, especially when in the professional context. Tax implications. Whereas co-ventures, each party is taxed on their shares, the GP income flows to partners' returns and as well as the individuals. So technically, the individuals have to file their own returns, indicate that they're in a business relationship, and the structures. They do a partnership income tax return, but it would usually be personally taxed on the individual themselves. It's a bit more complicated. So in this aspect, I would always recommend speaking to a accountant who would be able to assist you in this perspective. They would actually provide you with a better detailed information on how to get taxed and how to prepare your tax forms so that you're not risking any kind of business loss or any kind of CRA tax implications. The LLP also passed through, but may have withholding or registration. So these are, remember, these are LLPs that are partnerships that have liability, but they also have individual taxations as well as the partnership taxations. But the partnership taxation is just informing the CRA that you are actually getting taxed, and this is the amount of stuff, this is the amount of taxation within the business, and this is the amount but usually your personal taxes is what's actually constituted in the CRA as going forward. But again, speak to a CRA, not a CRA, speak to a tax accountant, and they will be able to assist you in this more thoroughly. Choosing the right structure for you. What is the right structure? You don't know yet, and you might not be able to discern that yet. So write down what you're expecting from a partnership, because there's high expectations. You might think that in a partnership one person is doing all the decision making, and you're just not getting involved, and your partnership is just based on you becoming a partner, and you're getting investments for your partnership, and you're dealing with all this stuff. But then the partnership might not work very well. So these are things that you need to discuss at the beginning of the partnership. Who's making the decisions? What kind of decision making process are we taking on? How is the investment going to be allotted? What kind of shares are you getting? And as well as what kind of financial and fiscal responsibilities do you have? Consider all of these possibilities before you actually continue into a partnership or a co-venture. If you're doing a co-venture, are you expecting to grow it? Or are you just expecting to continue one specific venture by itself without having any further contacts except the income, a specific steady income? Are you doing it just for a specific steady income? Then it's a co-venture. And if it's a temporary, oh, this is only a short term for a couple of years, and this is specifically just you're categorizing, make sure you know what you're actually expecting. These expectations will allow you to actually grow the co-venture into a partnership, and then you may have that partnership develop and become a bit more of a complex business structure where you decide, okay, now we need to go into a corporation. So these are things that you need to discuss at the beginning. What are your expectations? What are your long-term goals? And what type of fiscal responsibility do you want? What kind of liability do you want? And if you don't want those liabilities, how do you prevent these liabilities? If you don't want tax consequences, how do you deal with the tax consequences? If you want to limit your tax consequences and your liabilities, how would you structure your business so that you don't incur hefty responsibility for your partner? These are things that need to be considered. Like if you want to have a limited tax consequences because you don't want to have any high risks, and then you go into a limited partnerships. That would help you have a limited amount of income coming in, and it wouldn't be taxed on a higher rate. So think about these consequences. When to transition structures. So this is important because we don't know what the level of risk you want. We don't know what the grade is, how you want to grow your business. Do you want to become a corporation? Do you want to have shares in the long run? Or do you want to stay as a partnership? Or if you have like 20 partners now, is this feasible to have a general partnership? Or would it be better to have a corporation and get all of these 20 partners to become shareholders? Do you want to transition into a bigger firm? Do you want to limit your liability? What are the business risks? Are you scaling up or down? What is the consequences of your liability if you do these actions? Think about them, because when your business starts growing, things change. What once worked for you will no longer work for you when you have 20 plus employees. And this will have to be changed into a structure that'll benefit you. So, in order to do that, you need to get a better contract. You need to be able to make sure you have a better agreements. You need to make sure you have specific structures in place. And you need to also make sure that the tax consequences are limited, or they're not limited, but at least you understand the consequences of the structure that will create tax benefits or increase taxation on your companies. So these are things to consider. What is best to do in your business structure when you grow? Regardless of the structure, you need solid contracts though. Remember that solid contracts and solid agreements, well, they're basically the same concept, but specifically, in the partnership agreements, you want to put in place what kind of shareholder shares each individual might have, where the investments are coming from, what kind of liabilities you're going to incur. These are things that you need to consider. Common mistakes. Regardless of the structure, you will need solid contracts. So again, make sure you have solid contracts, solid agreements, and make sure you're following the regulatory requirements. Partnership agreement, the Corporations Act, whichever agreement you choose to make. Make sure that you have put into place things that will limit your liability and create better foundation for your structure so that in the long term you're able to build a organization that won't fall or collapse at the smallest issues that come up, including if you get a lawsuit against you. Now, what are you going to do with those lawsuits? How are you going to pay for them, or how are you going to deal with them if you end up having liability? Creating these agreements with built-in like safes, like if you have an employee, have you provide like there's specific structures that you need to follow if you have an employee, so that you know how to give them a warning if they commit an offense, or if they deal with a if you do they do a mistake. The same thing goes for a business structure. Prepare your business structure so that you can put into place all of these safeguards before you go into the business. So, sorry, common mistakes. No written agreement. This is important. Choosing based on a simplicity does not fit. So make sure that you're actually choosing based on the actual structure and all the like, okay, what amount of investments you're providing, how the business is going to work. Ignoring provincial regulations is a no-no, like because when you go to court, they will actually say, nope, you're following this regulatory requirements. So in that perspective, you're always going to end up back in the legal system, fighting the legal system, and your business is going to struggle if you do not follow the regulatory requirements. Not reviewing structure as the business evolves. So when you grow, make sure you review your income as well as your business structure, because once your business income starts growing, you might need to hire employees. You might need to get more supplies. You might need to hire that warehouse or like rent out that warehouse to be able to have those supplies. You might need to hire you might need to get more partners and more investors. So these are all concepts that you need to figure out how the structure is going to work, how you need to prepare contracts to be able to limit these liabilities, and make sure you protect yourself and your business as it grows. So, key takeaways today: consult a lawyer, an accountant, and any advisor, business advisor that may assist you in structuring your business, as well as the lawyers who can help you with contracts and agreements to make sure that your partnership agreements and further any kind of agreements, limited partnership agreements, are structured properly. And as well as if you have employees, you want to have employment agreements that are actually safeguarding you and the employees so that you protect yourself in the long run. Draft clear agreements. Make sure you consult a lawyer on this, because I understand that you can draft any kind of agreement, and there is a lot of AI technology now. And yes, they're very efficient, but they always have little tidbits that you may not be aware of, and the AI might not be aware of, because your circumstance changes from individual organization to business structures to anything like you do. Your organization might be completely different. It's not a generic organization, and you have to take into account every aspect of that organization. Reassess structures yearly. This is important because once you start growing, if you start going from a five-figure salary to a six-figure salary in a month, and then monthly you increase on that level, your growth is not only the monthly increase. You might have to actually increase everything: productivity, your employment agreements, your business can go from being a sole proprietor to be a corporation, because you want to see how the tax consequences can change, and you want to be able to reduce your tax consequences by creating a shareholder agreement, and all of these aspects that might actually benefit you in the long run. So think about these things. Align your choice with your business goals, risks, and regulatory needs. So, as I've discussed throughout this whole seminar, you have to look into all of these aspects before you actually consider any of these business structures. And you have to be able to know that it's not going to be a simple yes, oh, I'm going to do this. Your business grows, your business changes and evolves over time, or sometimes it might just dissipate depending on the situation. But even when you dissipate the business, when you decide to dissolve the business, make sure that you've actually figured out how to reduce your liabilities. Because if you have debts, you're still going to have to deal with them. You can't, if you don't have insurance or if you don't have specific protection or contracts, you might end up paying yourself. You might end up paying by yourself that 400,000 or 500,000. That's a liability that needs to be paid off. Protect yourself. Make sure you look at the legal consequences. Thank you. And I appreciate everybody for attending this week's seminar. And next week, because it's a long weekend and I know everybody's going to be trying to get away or out of the city or dealing with other things and they want to have time to spend with their families, and I'm going to try to make my seminar on Thursday in the afternoon at around 2:30 instead of Friday. So please stay tuned and we will let you know what's going on in next week's seminar. Thank you.